Evening,
Yeah,
members.
yes, ma'am. Please
Hearty
start, ma'am.
is Steady Circle Me. We have Advocate Madhuva Shetty to give a very brief introduction about her. She is working with universities to provide understandings of intellectual property rights, especially in the context of research since 2000. Was working with legal officer with respect to trademark filing for institution in case 19 to 20, and during 2016 to 2019 she was working with Krishnamurthy and Co, joining the intellectual property rights team in 2016 and working on it. And she has delivered talks on various topics and like importance of intellectual property rights, and she's also delivered talk on importance of requirement of intellectual property rights in many occasions in Rotary Club also. This very brief introduction, I wholeheartedly welcome to you, ma'am, for today's program. Hearty welcome to you. Yeah.
Thank you. I just give me a minute. Let me just try logging in through another device.
Yeah.
I'm going to be speaking about a topic which, I mean, it's getting a lot of ground right now. It's gotten quite popular. It's intellectual property rights. Was mentioned before, it's my area of expertise. It is what I've been practicing for almost 4 or 5 years now. It's something that a lot of companies and a lot of a lot of companies and just generally in the economy, there's a lot of importance that's been given to it now. There's a lot of development, there's a lot of growth that's happening with respect to intellectual property rights today in the Indian legal sphere, the economic sphere. So the government also is doing a lot to push forward the thoughts and the process of intellectual property rights and to streamline it so that businesses and startups, entrepreneurs have get the benefit of this law, of this legislation. So to begin with, just generally, from what I understand, you all can put up comments. So how many of you can identify all of these trademarks? If you could just put in a comment with the number saying, I can identify X or Y, these many. How many people can identify all six trademarks? Great. I see a few comments coming in saying they can identify all of them. Now, that's the thing. That is the entire reason that you have something called intellectual property rights. It makes, connecting with businesses, identifying businesses so very easy for a consumer, which is the main thing that a business is looking for. Consumers. Yeah, I can see the names also coming in. Those are right. The next thing is, can you, it's a very famous movie again. This entire tattoo was actually copyrighted, and that's the significance of having intellectual property rights or trademarks, copyrights, various sorts of intellectual property rights. You can protect your work and ensure that they're not being used in ways that you do not approve. For instance, in this particular case, the tattoo artist who created that particular tattoo that was on Mike Tyson actually sued the company, sued the film house that created Hangover because they used the exact same tattoo design without his permission. Of course, the matter was settled independently out of court, and the details of that settlement was never disclosed. But it has a lot of impact in the way that businesses And in general, a lot of individuals, entrepreneurs, startups, MNCs, international relations, a lot of the exchange, the commercial agreements, the way they're carried out changes depending on the type of intellectual property rights that are applied. Very basic understanding of what is intellectual property. Intellectual property is anything that is a product of the human intellect, as is in the word intellectual property. It's an intangible property in most cases because it is something coming from the mind. It's intangible in the sense that, yes, you're thinking of it, you're creating it, but then you are putting it in a fixed format. So that intangible aspect that is then converted. Can you hear me?
Yes,
You're
madam.
audible.
Yes.
Yeah.
Audible, right?
Yes, you're audible, ma'am.
Oh, okay. So, this sort of fixing of intangible property into fixed property is what is ideally intellectual property. And this is something that I have divided into, just to make it easier to understand. Intellectual property, in my mind, can be of two types. You have your creative expression, which is your literary works, your dramatic works, your paintings, your blueprints, things where it's your creative expressions, where you are expressing the creativity of your mind in some sort of artistic format. That would be one way in which I see intellectual property. And the other way is in the industrial application of intellectual property, where you're talking about maybe an invention that has some sort of medical benefit, which has some sort of industrial application, where it's enhancing some sort of business idea. So, things that have an industrial application, which is used more for commercial purposes, I have included those under industrial intellectual property. Now, again, what is the importance of intellectual property? Intellectual property, like I said, is gaining a lot of, it's gaining a lot of momentum right now, because people have realized that by protecting their intellectual property, by registering their intellectual property, certain benefits. And these benefits are essentially that they are recognized by whatever authority is regulating that intellectual property as the creator of that intellectual property. And recognition as the creator will give you it ties in with getting the following benefits. So if you are recognized as a creator, you get certain financial incentives, because you can then use your intellectual property in some sort of way that gives you monetary benefit. It could have cultural and industrial significance, because a lot of times intellectual property is applied so that a particular culture is protected, is recognized. So if suppose you have a geographical indicator, which is a type of intellectual property, you are extending some amount of cultural significance, because you are acknowledging that particular product or that particular art comes from a certain culture, from a certain application of skills that have developed in that area culturally, and you are acknowledging that and giving that recognition. So that's the cultural significance. Industrial significance, again, is where you are using that intellectual property and applying it in an industrial setting and boosting that industry's research and development. The benefits that they will get by being the sole user of that particular intellectual property, should they choose to. And another way that it helps the creator is that it ensures that if it is a product or a service, that they are the and genuine products in the market. When I say this, it works twofold in the sense that it ensures that no competitor is using a similar trademark or a similar product, and uh, making use of some other competitor or some other company's reputation in the market. That is one way. And the second way is by ensuring that the consumers are protected from, say, knockoffs, or products that are passing off as an original product. So tomorrow, if there are two bags, one is PUMA, Puma, and the other one is POOMA, Puma. By virtue of PUMA being a registered trademark that is so widely known in the market, most consumers will immediately realize POOMA is not genuine and will opt for PUMA, knowing that it is a genuine product. That is the intention, or the benefit that you get from applying intellectual property in one sense. The next thing that it does, it provides a revenue stream. Again, this ties into financial incentives, because there are multiple ways in which you can use your intellectual property to get financial benefits. You could sell your intellectual property, you could license it, you could make it available as free to use, as open source software is a good example of this. There are different ways in which you can actually monetize your intellectual property. And of course, the last thing that that most people, and the aspect that the government is focusing on quite a bit these days, is that protecting intellectual property helps promote research and development. And how it helps promote research and development is, again, by providing all of these factors in, because no person will want to research and develop something if he's not getting any sort of benefit. If he's not being recognized, a lot of people will not look into finding new and creative ways of producing or putting out new products, for finding new ways to do things creatively. So intellectual property rights, in essence, looks to promote the research and development, to promote the growth of economies. And the best way to do that is to ensure that businesses and companies that are actually looking to innovate get some sort of benefit from their innovations, from their hard work, from the money they've put in for their research and development. These are the returns that they get, essentially. Now, again, like I said, a lot of people do not realize, but intellectual property rights are quite various. We have a lot of legislations that are covered under intellectual property rights. Some of them don't even have legislations. They come under common law protection, but the main the rights that are available as of now are patents, trademarks, copyrights, geographical indicators, industrial designs, semiconductors, integrated circuit layout designs, plant variety protection. Now, I will be touching upon mainly on patents, trademarks, and copyrights. Geographical indicators, where you are giving protection, you are recognizing that a certain good or product develops in a certain area due to the geographical and cultural factors in that area. So, for example, you have Nagpur oranges. That is one of the famous geographical indicator examples that you can give. You know that an orange is coming from Nagpur, and you know that that Nagpur orange is of a different standard from other oranges. So the minute you say Nagpur oranges, you know, okay, fine, this orange comes from Nagpur, and that is what makes it a geographical indicator. The same thing with, say, Banaras silk. You know the silk is coming from Banaras, which is what is making it so special. Or Mysore beetle leaf. is another geographical indicator that is actually recognized. And again, not every betel leaf can be called a Mysore betel leaf. So that is the sort of scope that geographical indicators have. Industrial designs is a little similar in this to copyrights to a certain extent, but essentially it's the designs, industrial designs, and the Designs Act looks at the aesthetic application. Semiconductors, integrated circuit layout design, as the name says, looks into protecting your hardware, your semiconductors and your circuits, and the way they are laid out. So the layout the design and the layout that they have, those are protected under the SICL. And the plant variety protection is primarily under your biodiversity and protection of plant variety. So essentially, it's looking at your GMOs and how exactly do you use your plant varieties, what are protected plants, how aspects also are covered under intellectual property rights. Another aspect that usually does not, that is not covered in the sense that it does not have a legislation, but very much is an important part of intellectual property rights, and will be discussed towards the end because they are very important when you're talking about intellectual property rights. You cannot miss them. Is the trade secrets, or the ensuring that you protect all your trademarks, your patents and your copyrights, and that is through trade secrets, or making sure that confidentiality, all of that ties in very strongly with intellectual property rights, especially from a business perspective. Now again, I am going to be, like I said, I will be talking on trademarks, copyrights and patents primarily. And what I will try and do is try and tie that in with how exactly it would affect a company, and how businesses could use these a little bit more effectively, and how they can how you can try and help your clients to make better use, I would say, of the intellectual property rights that they know they have but are not utilizing, or B, are unaware that they can actually protect. Because this is something that has come up quite often, where they are unaware that they have certain rights, or that there are certain ways that they can protect their rights. So I'll start off with trademarks. And trademarks is a concept where you are essentially accumulating all your reputation and your goodwill that the company has garnered from its consumers, and that goodwill is represented through a certain mark. What this means is that in the first slide, by looking at a particular mark, like say the golden arches of McDonald's, you immediately know, even if there is no McDonald's written anywhere near those golden arches, if you see that arches anywhere in the world, you know that that is a McDonald's, and there is a certain standard of food that you will be getting from that particular outlet. And that is the entire purpose of trademarks in a nutshell. You are trying to ensure that your consumers are able to effectively identify your able to identify your particular company or your business. And also you're trying to ensure that they do not get fooled into thinking that a competitor or some third party's business is your business. So essentially, trademarks need to have certain essential aspects to be registered or to be considered a trademark. It should be a mark which has graphical representation, which means you should be able to represent or to put that particular mark in a fixed format. It could be anything. It could be a word. It could be a picture. It could be a label. But it should be in some sort of graphical representation which the eye can see. That's one thing. And it should have usage in trade. So if I have a trademark or I have a particular mark, I should be able to use that mark in trading, in the market. It should be something that people can see in the market and can use in the market. And most importantly, it should be able to distinguish your product or service, the business product and service, from any other third-party product or service that is there. Two bodies or two businesses have two separate logos. Those two logos should be so distinctive from each other that they're able to distinguish each other. Again, like I said, it can be the way that you are, using that trademark. It's the colors, the uniqueness being maybe some sort of symbol, the way it's written, but it needs to be distinguishable and distinct. Now, like I said, we've been having a lot of leaps and bounds are being made. We've had a lot of new sort of trademarks as well that have been introduced, not recently, but throughout the years. In India, we've had a few cases, but these are all trademarks, types of trademarks that I've identified worldwide. So the first type of trademark, which is the most common trademark and something that is applied for quite regularly in India, are the word or label marks. Essentially, these are marks that are made up of a word or some sort of logo, and these are what you predominantly see in the market. So, like I said, McDonald's is a very good example of this. Amul milk products, you know what exactly they are. If somebody says Amul anywhere in India, immediately it strikes up that image of the Amul girl with the distinctive yellow label or the distinctive blue label that they have for their dairy products. So those are things that would be considered as word and label marks, which would be the names and the logos. Then you have the sound marks. Sound marks are again somewhat new. Yahoo Yodel, the Yahoo that was very distinctive. So every time the Yahoo ad came, you knew exactly what they were talking about because of that the way they said the word Yahoo. And in 2008, they actually registered, there was successful sound mark registered in India. So, sound marks are also something that is slowly picking up now. Another example is MGM, the Metro Goldwyn Mayer. They have the lion that roars. That has also been registered in the US as a sound mark. Smell marks, even though this had an application in the UK as far back as 1996, we've not had a lot of, I haven't found any other mark in India as of now, to my research. But in 1996, a Japanese company had actually registered a smell mark for their tire where they had introduced a scent of roses to the rubber. So essentially, a smell mark is where a particular product smells distinctively from any other product there. So, for example, tires have a very particular smell. But if you can make it smell in a different way, it could be possible that you could get a trademark because of the distinctiveness of of roses to rubber. And basically, what another aspect that was touched upon when discussing smell marks is that you need to make sure that the smell is not essential to the product. So you cannot get, for a perfume, you can't get a smell mark because that's an essential part of the product of a perfume. But to tires, smell of perfume is the smell of the tire, the perfumed aroma of the tire is not as important, and you can apply for a smell mark. So it would be interesting to see something like that in India. I've not really seen anything with taste mark, but it is a concept that has been coming up where people are discussing if there is a way to trademark smells, there should be a way to trademark taste. So that would be something to look into. That would be interesting. You have your motion marks, which is basically anything where there is a moving object or an animated object. If there is a way to where that particular movement has become so essential to that particular product and that brand that they're selling, then you can trademark it. And interesting, there are two trademarks that I could find with respect to motion marks. Again, not in India, these are foreign registrations, but very interesting. Motion marks is the Windows logo where the colors keep switching. The animation for that has been trademarked as a motion mark, and the opening and closing of the Lamborghini doors where it goes up and down, I believe, that has been registered as a motion mark as well. A hologram mark is again where you are recording the refraction of light. And in India, we've not had a hologram mark, but we have had a registration in the US where the American Express, the credit card company, has registered for a hologram mark for the hologram that is applied on the surface of its cards. So, you know, that's an interesting aspect to it. Another thing is shape marks. Shape marks fall under, in a sense, part of your trade dress, the way that something looks, the way it is put forward in the market, it's packaged in the market, could be a shape. The Coca-Cola bottles, those are trademarked as for the shape of that distinctive shape of the Coca-Cola bottle. And another aspect to this, which I've not covered here, but it does tie in with trademarks, is trade dress, which is your packaging, the color, the way it's used, the way you've used your colors, the way you've used your fonts. As a whole, your packaging could be considered as trade dress, and you are given ways to protect that particular aspect as well. So in case you find that somebody is infringing on the way that the product of a company looks, there is a way to protect that as well under trademark law. Now again, you know, like I said, there are, in essence, what you're protecting in a trademark is your goodwill and your reputation that you've accumulated through your business with consumers in the market. And I have divided that into two aspects over here. You have, first of all, you have difference in with respect to rights and trademarks. You have differences depending on what type of trademark you have, whether it is an unregistered trademark or a registered trademark. If you are registering your trademark, you will be registering under the Trademark Act and the Trademark Rules of India. And both of these together lay down the procedure which needs to be followed while you are registering your trademark. So it tells you all the steps, all the things that are required, all the documentation you will need, the procedures you need to follow, who is the appropriate authority. All of those are listed between these two acts, the Trademark Act and the Trademark Rules. Now, suppose a company or a business decides, I don't want to register my trademark. That a company or a business has to register its trademark. So if a company or business does not register its trademark, it falls under common law rights. So while, you know, suppose in a situation where there is some sort of third party that is copied or using a similar mark or an identical mark, if it is a registered trademark, if company A, for example, has registered its trademark ABC, and company B decides to use AB as its trademark. In this situation, company A could, because it is registered, could apply under the Trademark Act and say that there is an infringement to my rights, my registered rights, and you know, this is an infringement case, and they can move forward and take the matter to the courts under the Trademark Act. Now, in case, say, company A is using ABC but has not registered its trademark, and company B is using AB, company A still has rights against company B. The only thing is that they will no longer be going under the Trademark Act. They will be going under common law rights, saying that company B is using a similar mark to mine, and they are trying to pass themselves off as me to the consumers in the market. So yes, you get protection whether you register or you are not registered. But the protection that is given when you are registered is a little stronger because you will have a registration certificate from the government. So essentially, by registering, you are giving your. So that is one sort of differentiation in the rights in a trademark. The other one is whether the mark itself is an ordinary mark or a well-known mark. And again, in this, there's a difference in the rights that are given for a simple reason that in an ordinary mark, you have to essentially, you have to show that this is my mark, and I've used this mark for so many years, and you are essentially saying that yes, I'm operating in the market, but I have a reasonable amount of goodwill and reputation. However, a well-known mark is any mark where it is so like it has been marketed and it has reached a level where any reasonable person in the market will know of that mark wherever they live, to a certain, at least you are sure that at least 80% or 90% of the market, for example, will know of that mark. So for example, would be um, Pepsi. Pepsi is a well-known mark in India, and to be a well-known mark, there are certain criteria. You cannot just claim that you are a well-known mark. To be a well-known mark, you either need to apply to the trademark registry saying that I am a well-known mark. There is a particular application form that needs to be filled out and given to the trademark registry, where they will then examine and decide whether yes or no, this particular mark should be registered and take, no, given the connotation of well-known mark. Or else the second way to get it is in dispute before the court acknowledges that that particular mark is a well-known mark. As of now, these are the two ways in which a particular trademark can be considered a well-known mark. And if you are a well-known mark, again, it is a good amount, you get a good amount of benefits because it is very easy to prove that I am such a well-known mark. There is no way that my competitor could not have known me. And by using a similar mark, even after the fact that I'm using a well-known mark, they have clearly copied me. So there are certain benefits of being a well-known mark. An ordinary mark again would be any mark that you've applied for to the registry. It just becomes a little bit more difficult to prove, whether there was any sort of malicious intent in the copying or whether it was knowingly copied or not. But again, both of them do have their benefits. Both of them have their rights. It's just a difference of proving whether or not your competitor or the third party who might have been infringing or passing off on your mark, whether or not they knew about your mark. Examples for a well-known mark would again be Amul, Pepsi, Benz, the car company, Mercedes-Benz, McDonald's. These would all be examples of well-known marks. Again, this is a very interesting case. I'm sure you can see these two. There are two creams on the side, side by side. And until and unless you pay attention very closely, you do not, they look very similar to each other. So this case is Glenmark Pharmaceuticals versus CureTech Skincare and another. So in this case, one is Candid B, which was by Glenmark, the company called Glenmark. And you had Claudid B that was being sold by Galfa Laboratories, the company is Galfa. And what happened here was that Glenmark noticed that there was a similar product in the market, very similar to their product. It was, both of them are antifungal creams. So if you see the ingredients that they've listed on top, the chemicals that they've used, it's the same. It's pretty much the same. It's the same components that are being used. One is Candid B by one pharmaceutical and Claudid B by another. So in this case, when Candid B actually went ahead and sued Galfa, saying that your mark is very similar to ours and it's clearly infringing our rights, Claudid B did not really, defend themselves. They just said we were not aware and things like that. And another thing that was found by the court was that Claudid B, Galfa, which created Claudid B, was a habitual offender. This is something they did very often. They would find a competitor's product, they would use something similar and put it out of the market. Now, of course, the court, gave an injunction. They said that Galfa was wrong. They had to, pay damages and all of that. But now, why this is so interesting is because, these are medicines. In a country where, a lot of times the consumers might not realize the difference. In our situation, yes, to a certain extent, we can see the differences and stuff like that. But when it comes to products like this, where the trade dress is so close to each other, the way it's being marketed is so close to each other, sometimes you do not realize. If you see red, green, and something with a C and a B, a lot of times consumers, when they're in a hurry, will just pick it up. Or the pharmacist who is giving the medicine might, while they're dealing with so many people, might pick up Claudid B instead of Candid B. Maybe, and by doing that, there is an effect to the revenue of the company Glenmark, which has created the original product. Because by infringing or by copying this, the market which should have come to where the consumer should have been buying Candid B, they are now going to buy Claudid B, and the revenue that is being earned, the money that should have come as profit to Glenmark, is now being diverted because there is another party that's making use of the similarity between their packaging to get some sort of benefit. So this is one of the reasons why it is so important to make sure that, when you have your product out, to make sure that it is not infringing on somebody else's right, and to keep an eye to make sure that somebody else is also not infringing on that particular trademark. This is Glenmark and Galfa. This is again a similar, not similar, recent case. It is Aswa versus Rampur Aswa. In this case, the Aswa was a Scotch, that was being sold by Meher Distilleries, and they had filed a case against Radico Ketan, which was selling Rampur Aswa. And what they essentially said was similar to each other, and this is infringing on our trademark. In this case, it went to a single court, it went to a single court decision. It then went to the High Court. There was a lot of discussion, but essentially, what was, finally said at the Bombay High Court that, heard the case last, what they said was that there is phonetic and phonetic similarities. Sorry, more than visual, it's phonetic similarities between Aswa and Aswa, in the sense that they do sound very similar. They're in the same class 33 of goods, which is for alcoholic products. So there is a possibility that consumers could get confused by the phonetic similarity, and that does dilute the trademark of the of Meher Distilleries, who was the petitioner in this case. They also, pointed out that it does not, phonetic, you have to take the mark as a whole. You need to see how um, likely is it that the common consumer in the market is to, how likely is it that they will get confused between these two marks, and whether there is likelihood of confusion with the consumers in the market. Okay, so now we'll move on to copyrights. Copyrights, again, it is, again, like the name says, it ideally it is looking into the right to copy. So it gives the creator the rights over their work, and that includes, whether the right to particular work. Now, there are certain things to keep in mind with copyright. Copyright, what it protects is original works, and what it original works, but not the ideas of that work. What it protects essentially is the expression of that idea, the way that something has been expressed, the way an idea has been expressed. So, for example, the idea of, say, friendship is not copyrightable. But if I write a poem about friendship, the way I write that poem, the structure of the language and the structure that I've used to write that poem, that expression is protected. But I cannot stop anyone else from using the idea of friendship. I can't hold that right as solely my right. So that's an important part to keep in mind with copyrights. And the works that are primarily protected under copyright, under the Copyright Act of 1957, are literary works, which is your books, poems, maybe lyrics, your artistic works, your paintings, murals, musical works, songs, the instrumental, whatever is being played, instrumental sound recordings. Dramatic work, which would be your theater, and you have your cinematographic films and sound recordings. And another aspect that's also protected by copyright now is software. So computer software can also be protected. You can get a copyright for software as well. And the main thing for all of these works to be protected by copyright, they need to be in a fixed format, which means a literary work needs to be written, or then it some sort of fixed format where it can, where it can either be seen or heard repetitively. So an artistic work, it would have to be painted. A musical work would have to be recorded. Same thing with the dramatic work and cinematograph films. So you can't claim a copyright to something that's in your mind. Your copyright only exists once that concept that is in your mind is been put down onto paper or onto, say, some sort of medium that can record it. Now, again, so this is something that a lot of companies do not realize is essential. There are various factors regarding ownership of copyright. One is that, again, like I said before, what you can protect or what you own is the expression of that particular work, not the idea. So, for example, if you have a jewelry company that comes and says, this is my intellectual property, I have created this bee, maybe it's a bee brooch, and or a butterfly brooch, let's say a butterfly brooch, and they say, now I own the copyright in this butterfly brooch, no one else can create a butterfly brooch. That is incorrect. What is protected is the way that they have made the butterfly brooch. Does it have 4 wings? Does it have 2 wings? What are the colors used? Is there any sort of other creative or artistic elements to it? Is there something that makes it unique? That aspect of it can be protected. That jewelry company cannot stop anybody else from creating or from using butterflies to create jewelry. They can suppose they butterfly brooch, they can probably stop somebody else from maybe using a similar color combination, and maybe if they have swirls in the wings, maybe they can say, yes, that's very similar to my work. Based on various factors, it might be possible to say that there has been some infringement, but they cannot stop the entire market from using butterflies in their jewelry. So that is the division between idea and expression. What is protected under copyright is expression. What is free for any person to use is the idea. The next aspect that affects ownership is your work for hire, or if you're getting an independent contractor to work. A work for hire, a person who's doing work for hire, by being hired by another person to do that work, will no longer hold rights in that work. It is given in the Copyright Act. It states that if somebody is doing work for hire, the copyright in the work that is created during the work for hire period, or as scope of the work for hire contract, that copyright or that intellectual property will go to the person who has hired the creator. Something similar that you see in the employment agreement, or that is something that should be included for employment agreements, is where it says that any employee during the scope of work for their employer, any IP or any copyright created during that time will vest with the employer and not the employee. So that is something that is very common these days. So what it ensures is that if somebody is doing work using the company money, that work that is created using the resources of the employer will revert, the rights to that will revert back to the employer. And the last thing that could affect ownership is an IP transfer agreement. Essentially, if you sell your IP or copyright in this case, you no longer are the owner of that copyright. So these are just a few things that might affect ownership. And when you're looking at, how exactly your company is working, what are the, what sort of assets does it have? These are things to keep in mind as to whether or not you actually have that IP, whether you actually own that copyright or not. Now, what are the rights that are given under copyright? And again, the economic rights, of course, are the basically the things that you can monetize and that you can make financial use of. And the moral rights are things that essentially are for protection in case of infringement or some sort of misuse of that copyright. So economic rights is basically the rights that a person or that the creator owns in that particular work, and that is the right to reproduce the work, store the work, distribute it, change it from, translate it from different languages, adapt it to different forms, make a film, a cinematographic film, or a sound recording. So there are different ways in which you can monetize your copyright. So essentially by using these economic rights, you create the company can create a financial a revenue stream for their finances. They can get funding by ideally by utilizing their copyright in moral rights are rights that are inalienable to the creator or the author of a work. And essentially, it is the right of attribution of paternity, which means that the creator who created the work, the person who created the work, will always be the creator. And even if he or she sells the copyright, or is under an employment agreement or a work for hire agreement, and the rights to that go to the employer, even in that case, the creator will always be the person who actually created it. So while the ownership can switch, the person who created that work will always be the creator and should always, essentially should always be attributed as the creator. The next thing is the right against distortion or mutilation, where if there's copyright, you can say that no, this work should not be mutilated, should not be changed without the agreement of the creator. And modification is similar, where you cannot modify the work without asking for permission from the author or the creator of the work. Now, there are certain exceptions to copyright, and we call them the fair use or the fair dealing provisions under the Copyright Act. It essentially says that yes, a person has copyright or has certain rights in the work that is created. However, if it is being used for certain aspects or for certain purposes, it can be considered an exception to those rights, and the person can use it without a license. But those also are very particular, such as if you're using it for research, for criticism, if you're using it as, to criticize that particular work, if you're using it to review that particular work, if it's part of, say, a news report, if it's a proceeding, or if it is part of education and teaching, if it is an act, if it is some sort of, version recording or some sort of backup or, to software that you've used, all of these can be considered as exceptions to copyright. Again, an interesting case for this would be the DU photocopying case. That was Delhi University had the photocopying booth over there, I believe, had created mass copies of entire books, which were it basically photocopied substantial amounts of certain research material and all of that, and it had been distributed to the students. And there were publishing houses that actually filed a case saying that this is not acceptable. It's a violation of our copyright in those books. Unfortunately, it would have been a very good precedent, because it actually does talk about to what extent can you use fair use, how much of how much is considered fair use. Unfortunately, it was settled out of court, so we still don't have anything very substantial, to the best of my knowledge as of now, to what exactly would be considered fair use of copyright. And before I touch on that, there's also another aspect that I wanted to talk about with respect to use of copyrights. You see them in a lot of political movements also, where sometimes political parties and politicians use copyrighted work without permission. So, always, if you're using some sort of material, always make sure you have the appropriate licenses. I think a good case of that was where Donald Trump used Rihanna's music at his rallies without her permission. And that created a huge problem, because I have not given permission to use that music, and that is an infringement of my copyright. So, just something to keep in mind, that this not only affects businesses and companies, it also affects a lot of, you can see a lot of this in day-to-day life in aspects where you might not even realize. So yeah, that is copyrights. And the last part that I will touch upon is patents. Now, patents are essentially a statutory right that is given for an invention, and it's given for a certain amount of time. So it's given for 20 years from the date of the application being filed. It excludes everyone else from making use of that patented product or process. Now, what exactly can be patented is an interesting topic, because it's a situation where it's not been as clearly laid down. It's not been laid down the same way it's been laid down in the Copyright Act or the Trademark Act, where they say that this can be copyrighted. This is what is protected under copyright. The patentability of a product is a little different compared to copyright, in the sense that if an invention needs to be patented, there are certain, there's a test that needs to be followed. The primary test, it's called the Nunn's test. N being novel or new. It should be, U being, it should be uniform. it should be capable of being uniformly applied in an industrial setting. So if you have some sort of invention, every time that output from that invention should be uniform. So every time you use that product, or that, say for instance, maybe a machine, every time you use that machine, the output of that machine should be identical and uniform. The next N is, it should be non-obvious. It should have non-obvious steps or inventive steps. What this essentially means is that for a particular patent, yes, it should be novel, but it should be something that a person having ordinary skill in that art should be able to say that yes, this is a non-obvious step that actually adds something to the process. So for example, if you have say for example, you have a water bottle, and all water bottles till today had a flip cap. Somebody decides, okay, fine, I'm going to change it. I'm going to make a screw cap. The person who is ordinary, who ordinarily makes these water bottles should look at that new step, maybe, the step of screwing the bottle on and saying that, yes, this is a non-obvious step that a person who has been making water bottles did not think of. So that is the sort of non-obvious step that should be there. And the last S that is mentioned here is that it should not attract the provisions of Section 3 and 4 of the Patents Act 1970. The reason that this is this is so important is because the Patent Act of 1970 does not state what can be patented. Section 3 and 4 of the Patents Act lists out what cannot be patented. So if you have something that falls under Section 3 or Section 4 of the Patents Act, it will not be able to you will not be able to patent that particular matter. So you have to be careful. So Section 3 and 4 essentially, like few of the things that it mentions is that if it is a mixture, if it is some sort of living organism, if it is something that is ordinarily found in nature, these are things that you cannot patent under the Patents Act of 1970. Okay, so of course, I'll just briefly let you know about the steps to patent. So if you are if a company is looking to patent a particular product, they have to draft their provisional application, and then after which they have to publish a patent application. And once, so you can draft first a provisional application, after which you need to draft your complete specification. After that, that specification is published in the patent journal, where it's kept for 18 months, after which you have an examination of the patent application. And from then on, it moves on to, responses being filed. And then if it's accepted, it goes on to being a registered patent. If not, you can either go on to having a hearing, or, getting, the application not going through at all. And the thing with the patent that a lot of companies do not realize is that every patent it needs to be renewed every year. So there's a renewal fee to be paid every year when you have a patent application. For trademark applications, it's a 10-year, every 10 years you need to renew it. Whereas for patent applications, the patent period is 20 years, but there's a renewal fee to be paid every year. Now, this is, I think, something that a lot of companies do not realize, or, have. These are things that, I have seen a lot of my clients coming to me and, saying, we didn't know that we should have done these. So these are things that they really need to keep in mind. The first issue that they face, or, that companies are not aware of, is that they need to be researching before launching a product or a company. Very often, companies will, individuals, businesses, startups, they'll think of launching a product or starting a company, but will not carry out the required research. And by required research, I mean this includes general, like a Google search. What I would recommend when, if a company is looking to launch a product or a company, do a Google search, do a company search. If you're looking to register a company, do a company search, do a Google search, and also find, if you are not comfortable, find a trademark lawyer or an IP lawyer who can conduct a trademark search, who will be able to identify whether there is already somebody who has registered a mark which is something similar to the company name, or the product name, or the service name. By doing your research beforehand, a lot of the problems that are going to come up at a later stage are cut out. You can preemptively create a strategy for that company launch, or for that particular asset to the company. Another thing is, a lot of companies don't keep their products or their company name secret. And what they don't realize is, sometimes you need a certain amount of secrecy in your business. Non-disclosure agreements, having confidentiality agreements are great ways to protect your trade secrets. And ideally, by trade secrets, what I mean is maybe some sort of intellectual know-how, where maybe it's some sort of new product that you've created, which is the first of its kind in the market, or if it is some sort of process that is one of a kind, or if it is a very inventive name. Because what they don't realize is, in India, the trademark policy that is being used is the first person to use, not the first person to file. So if somebody, suppose before you even launch it, before you use it, but you let people know, you let all your, suppose you're tying up with suppose a company's tying up with, say, company A, B, C, and they let them know, we are going to be launching this, we're going to be launching that. Sometimes companies A, B, and C can be like, oh, that's a good idea, let's make use of it first. That trademark is very creative, let's try and use that and launch our product under that name. That could happen. And if that happens, there's no way to show that, I mean, you really you'd be in a sticky position, the company would be in a sticky position, because it'd be very difficult to show that they have launched first. So, I mean, NDAs, non-disclosure agreements, confidentiality agreements, keeping trade secrets could be something that a lot of companies should be adopting even before they get into any sort of discussion. Another thing is looking for protection after launching. This is very common. It's happened so many times. Companies will launch everything and then look into signing agreements, or look into signing, going in for registrations. It's very last minute, including, registrations that they require, things, common, and that is something that should be made note of, because a lot of times the protection is not as effective. Like, you don't get as much benefit if you're applying for it or trying to get it after the issue has, like, suppose some sort of infringement, or after some sort of problem has arisen. Getting the protection after that is not as effective as getting it beforehand. And the next thing that is very prominent with a lot of companies is they're not aware of what type of protection they require. For example, a lot of companies don't realize that to have an effective protection for their company or for their business, they need a mixture of rights. So you have your registration under the Companies Act with the, under the Register of Companies. You need to get yourself registered. Yes, that's important. But along with that, a good way to provide yourself with extra protection is to also register your company name as your trademark. Because what people don't realize is, yes, you can apply, a lot of times people will check, and I mean, when you're registering a company, they will only look at the company register. What they fail to understand is that the company, when the registrar also looks at the trademark database to see if somebody has registered something similar. So if you really want to protect your company and your business, a good way to do that would be to register your company name, your products, your services with the appropriate trademark or the appropriate copyright or the appropriate patent, depending on what the situation is. And another thing that that should be kept in mind is also you have you can use multiple protections for the same product. So suppose you are giving a service, you could register it through various ways. You could register it as a trademark. You can register it as a copyright. You could maybe get a patent registration for an invention, and then also have a trademark registration for the same product because you're selling it under a particular name. So a good way to help a company with its intellectual property, which is considered as an asset, is to figure out the best ways to get protections for those particular assets that they have. Now, how to protect your intellectual property rights? So a lot of companies these days know about intellectual property rights. They've started, figuring out that yes, we need these intellectual property rights. Unfortunately, they've not figured out how to protect your intellectual property. And intellectual property these days has become an essential part of a company for the simple reason that with the liberalization of our economy, we've seen a lot of MNCs, we've seen a lot of foreign entities entering into the Indian market as well. And a lot of Indian companies, try and breach the foreign market. And when you're doing that, having a strong intellectual property right base, having a good portfolio where all your intellectual property rights are protected is very important, because that's something that a lot of foreign companies look for. So a good way is to register everything. Make sure that all the companies have their registrations in place, that their registrations are up to have the certification for everything. The next thing to do is if it's say a corporation where there are multiple entities under maybe one main company, make sure, or if it's like a partnership or something like that, if there is multiple companies working together, make sure that the rights are all vested in one single entity, because it makes registering for new trademarks very easy. In case there's some sort of change in the trademark, in case there's some sort of dispute in the trademark, exactly, like the company knows exactly who owns it, who has the rights. There's no scope for entities in the same umbrella to fight amongst each other as to I own this and you own that. It becomes much stronger because that all the rights in all the IP is with this one entity, and they are the ones who have the right to then sell, to license or sign, how exactly it's used. All those decisions can be taken more efficiently. Maintain a portfolio is something that we tell all companies, mainly because how are you going to keep track of your trademarks, copyrights, and your patent registrations? Best way to do that is to maintain a portfolio, know exactly when you have applied for a particular right, how you've applied for it, what stage it's at, does it need renewal, when does it need renewal. All of these will help in ensuring that clients don't miss out on, say, renewing their certificates, and ensuring that the portfolio is up to date always helps that company's IP to we always tell companies to establish usage guidelines, because the way you use, the use of your trademark or your copyright, or the way that you use it, if it is consistent, it actually helps strengthen the IP further, because it is now established that this is the way that you use the trademark or the copyright, and everybody in the market will realize that this particular usage is how it is registered, and that is why it's being used consistently in that format. And most importantly is conduct IP audits, for the simple reason that you need to the company needs to know whether or not its IP is all in the correct format. Is it all registered? Is it all renewed? Is it still, what are the trademarks or the intellectual properties that are still valid? What has lapsed? All of those things need to be kept in check. Also conduct IP audits in the sense that try and make sure that regularly checks are made in the market to ensure that no third party is using any sort of similar mark or something that is infringing. So if you can catch those early before it gets out of hand, it becomes easier to ensure that your intellectual property rights are not diluted. Because if you do not catch them, if you're not keeping an eye on the market as well, it's quite possible that the company might dilute their rights because there's somebody else who's using the similar mark or a similar tagline or a similar copyright, and the company's not done anything to catch it or to reprimand them, so it could dilute the power of that particular IP. Because that is something that happens during mergers and acquisitions as well. It's one of the things that a lot of companies have started giving a lot of importance to. These days, before any sort of merger or acquisition or any sort of transaction takes place, usually companies want to know, are all the documentation, first of all, company registration and company documentation, whether all of that is in place. And the next thing that they also want to know is whether the rights, the intellectual property rights, the license and the assignments that the company might have carried out, the IP contracts that have been signed or anything like that, whether they are all valid and whether it has all the documentation is in place. So IP audits, regular IP audits would also help in ensuring that later on, if there's any sort of transaction that's taking place or any sort of merger or acquisition taking place, any sort of takeovers taking place, it's easier, it goes much more smooth if all of these audits are done in a timely manner and you have all your documentation in place and your portfolio is a clean portfolio. There are certain contractual safeguards as well that, like I said before, companies should be looking into if they are, if they want to maintain a good and clean portfolio for their company. The first thing is if you have any sort of IP contract or even IP clauses in as part of a major contract, always make sure that the IP, the contract, the language that you're using in those clauses are strong and they are clean and everyone knows what they are. For example, if you say license, if it mentions that this is a license in agreement or this clause is regarding a license of certain rights, it means that it's on rent. The property in itself is not time for a certain amount. However, if the term assignment is being used in that IP contract or in that IP clause, essentially it's a sale agreement where you're selling that IP, you're selling that trademark or that property or copyright or that patent right. You're selling it if you're using an assignment. So if a company is ever looking, to conduct an IP audit, or it's looking into looking into getting into some sort of agreement or any sort of transfer, takeover, merger, acquisition. These are some keywords that that needs to be looked into to understand what exactly the contract is talking about. And something that a lot of companies are sometimes not very careful about and can unknowingly assign very valuable assets at maybe a very low cost. So that's something to really look into. Another thing is if you're having work for hires or memorandums of understandings or employment agreements and such, always make sure that they're very strong contracts with clear clear instructions or clear language as to who is the owner of the particular work, who is the author of the particular work, for what duration and what scope is the work. All of those things, if it is mentioned clearly, will make your contractual safeguards much safer, because the company and the employer and the employee in this case would have clear knowledge as to who and what exactly the IP is and who exactly owns the IP and how it's going to be used as such. Indemnity clauses, again, very important for the simple reason, should something go wrong, the company obviously would want to be indemnified. Suppose some third party comes up and says that the IP that was created, is actually infringing my copyright or my, would obviously want to be indemnified from that sort of a problem. And another good way to make sure that your your information, your trade secrets and your trade processes remain secret, are using confidentiality clauses and NDAs. And if you have a client who is looking to take over, to merge, to maybe collaborate with some other third party, always make sure that they sign confidentiality clauses and NDAs even before they start exchanging information, because I've had situations where clients have exchanged the information without signing the confidentiality clauses, and afterwards, after everything is done, they have come to us and they've said, we disclosed all of this, but we didn't have a confidentiality clause in place. Is there anything we can do? And the answer is no, because we do not have a Trade Secrets Act per se. It is the responsibility of the person disclosing the secrets to make sure that it is being kept secret. So confidentiality clauses or confidentiality agreements is probably the best way to keep your trade secrets secret, because even if they are disclosed, you can still injunct them. You can stop it from being disclosed further, or you can claim damages caused because of that misuse of the information that you have disclosed. This is a very interesting case as to intellectual property rights. This person is Nikola Tesla. I'm sure everyone will know of him. He's got the company. I mean, the company Tesla has been named after him. He was one of the most. He's considered one of the most brilliant minds today. But unfortunately, until the company Tesla really started climbing up, and Elon Musk really remembered Nikola Tesla for the simple reason that he really didn't utilize his intellectual property rights very efficiently. So, for example, he was the one who built the AC motor. In this situation, he was actually working with Thomas Edison. And Thomas Edison said that, I will give $50,000 to any person who can improve upon my DC motor. And Tesla did that. He went back, he looked at the DC motor, came up with the AC motor that is, which is considered one of the greatest inventions, because it really helped in generating a lot of electricity with, less input. So he didn't ask, there was no written agreement. Edison just said, orally, I will give $50,000. This man took it at its word, made this invention, came back with the AC motor, which is a definite improvement. And Edison then went on to say, no, that was a joke. I'm not going to give you $50,000. So, it became a huge issue, because this is where, your agreements and making sure that your rights are protected is so important, because sometimes things like this can happen. So this is an example I give to most people, saying that always make sure you have written documents. If a company is looking to expand, looking to do anything, make sure that, you have some sort of written agreement before you go ahead with anything. You also have, a case where he actually created a large-scale AC motor, and he registered, he finally got the patent for his AC motor, and he had actually licensed it out. And the thing about intellectual property, with every work that you with what you have, if somebody is using it, you do get royalty rights back. And these are important. But this man relinquished his royalty rights. And what happened was he ended up losing a lot of money, and he ended up having dying, a very poor man. So it's a very sad case, but it's an important case as to if companies don't use their intellectual property rights effectively, they're essentially losing out on a very important asset. Because today, this in the intellectual property rights have become almost, um, it's really become an important asset in the market today. A lot of companies these days, we have a lot of IT companies, we have a lot of software companies that where all their work is primarily on copyright basis, where they're using copyright software. And we all know that today uh, knowledge has become power. You need knowledge. The race in today with society, it's a race to information. Who can develop what first? And because of that, companies really need to keep in mind that some of the greatest assets that they have as a company, that they really need to make use of, are the intellectual property rights that are being generated within the company itself. So for example, if tomorrow company A wants to take over company B, company B needs to make sure that that all their intellectual property rights are in place, all of their documentation is in place, that there is nothing there's no infringing material in their intellectual property rights. And more often than not, there are multiple cases where a lot of big companies look into taking these startups, businesses, for the simple reason that they need the intellectual property that is being developed, in these startups or in these businesses. So really, today, in today's economy, I would say one of the best assets that a company has are the people and the intellectual property that these employees are generating in the name of the company. So that is it. That's basically a very brief introduction into three of the major, I would say as of now, major intellectual property that is being seen in India, that a lot of companies are worried about or want to register. I hope this has been helpful. In case there's any queries or clarifications, if there is any sort of doubts or something like that, I would be happy to clarify. If there's any points that need to be discussed, we can start with maybe an interactive session where I will try my best to clarify and respond to any queries that you might have. Hello.
Ma'am, can you please check the question and answers box and your chat box?
Sorry.
Please check your chat box and Q&A
So
box.
you have to be a little louder. I can't hear you. Hello. Yeah. Can you repeat that, please, Divya?
Madam, please check your chat box and your Q&A box. You would have received
Yeah,
some
the
questions.
chat box doesn't have any queries from what I can see right now.
Q&A, do you have anything? Suraj, please check now. I'm not able to see any questions here.
Yeah, ma'am. As far as this Q&A, no questions is chat. No chats questions are there. I'll check Q&A.
Yeah.
So far, no questions, ma'am.
No questions.
No questions. Yes.
So we can wind up the session, madam, or you have anything else to say?
I am done. This was my thing. This was it from my
Okay.
side.
Yeah.
So in
So,
case
all
there's
right.
any
Yeah.
queries, yeah, anything at all, I will put my details on the, suppose somebody wants to privately ask or, is maybe has some queries later, I will put up my phone number and email ID on the group. So in case anybody has any further queries or something like that, most welcome to privately message. Suppose you don't want to put it up here. Would that be acceptable?
Sure, ma'am. All right. Yeah, yeah. Please, please. You can post it.
I mean, some query might come up later on, or maybe something that they're not.
Yeah, yeah, later also. Yeah, yeah. True, true. Yeah, fine, ma'am. You can post it, ma'am. Yeah.
Yeah.
So, members will take this opportunity to present formal vote of thanks for today's study circle. On behalf of all the participants and on behalf of Bangalore branch, thank you, Madam Madhuva Shetty, for your spending your valuable time and giving an excellent presentation. Wholehearted thanks once again to you. Thank you so much.
Thank you. Thank you for giving me the opportunity.
Thank you. Thank you. Members, I would like to remind you, like tomorrow and after we have elections, so request all of you to kindly cast your voting. Please remember that, the voting is a responsibility and also a right to choose the right candidate. Tomorrow and after is the elections. Request all of you to kindly come and cast your valuable votes. And also 10th and 11th, we have National Conference on Indirect Taxes. Request all of you to kindly register for it and participate in it. Thank you so much. Thank you all.
I've put up my details in case anybody, wants to contact me. So thank you. Thank you again, Divya. And
Thank you. Thank you so much. Thank you. Suraj, you can wind up the session.